Hi, and welcome to the webinar on COVID-19 and asylum, hosted by the Women's International Study Center and also supported by the American Council of Learned Societies and Mellon Foundation. We have gathered here to give you some insight into how our project known as Practicing Asylum and all the work that expert witnesses and immigration attorneys are doing is being impacted by COVID-19. I'd like to briefly introduce our participants and then move on to letting them speak. And I'm going to go in the order that they will be speaking. First, Natalie Hansen, an immigration attorney and founder of the Austin-based law firm Hansen and Taylor. Then Maria Baldini Potermin, immigration attorney and founder of the Chicago-based law firm Maria Baldini Potermin and Associates. And then Dr. Kimberly Gauderman, an expert witness and an associate professor of Latin American history at the University of New Mexico. Gabriela Torres, expert witness and professor of anthropology at Wheaton College. And last but not least, Anna Cabot, an immigration attorney and senior staff attorney at the Center for Gender and Refugee Studies. So without further ado, we'll get started. I'm Liz Hutchison, also a professor of history at the University of New Mexico. Dr. Gauderman, would you please give us a brief overview of how the Trump administration has acted to restrict access to asylum?
Yes, the Trump administration has repeatedly taken actions to limit access to asylum protections through his attorneys general, as well as through executive decree. It's important to understand the challenges that we face through COVID-19 in the context of this continual assault on the asylum process. Now, the Attorneys General, Jeff Sessions, and Attorney General William Barr both issued decisions that limited and narrowed the grounds of asylum. In matter of AB, Attorney General Sessions in December of 2018 limited the ability of survivors of gender-based violence and gang violence to obtain asylum. He determined that in most cases, domestic violence and gang violence are private crimes, and therefore they do not merit asylum protection. In matter of LEA, Attorney General Barr in 2019 determined that most family-based claims are no longer grounds for asylum. This particularly limits cases for family members who are often targeted by gangs because of their relationship to a primary target. President Trump has also issued several executive orders that have impacted asylum seekers' ability at the U.S.-Mexico border. In 2018, he ruled on metering at the border, and this was a policy that only allowed a very strict number, a small number of people to cross the border and to apply for asylum. That was followed by the Migrant Protection Protocol, MPP, which is also known as the Stay in Mexico program. In that program, asylum seekers were forced back to wait for their asylum, for the asylum process in Mexico. And as of April 2020, over 60,000 applicants are waiting in Mexico. This was followed by the third country transit ban in July of 2019. In that ban, in this order, those who pass through any third country must apply for asylum in that country before they're allowed to apply for asylum in the United States. This was followed by the asylum cooperative agreements that President Trump's administration has been negotiating with safe third countries, those countries being Guatemala, El Salvador, and Honduras. And it's important to recognize that these countries are the origin of the majority of our asylum seekers that come to the Mexican border. These have been negotiated since November of 2019. And finally, last week, the Trump administration proposed new rules on June 11th. These rules would virtually end asylum protections. The new rules are comprehensive in the breadth of their restrictions, but among the changes that are being proposed is an attempt to rewrite the current asylum law in order to eliminate multiple grounds under which people are currently granted asylum. And these rules would allow immigration judges to reject asylum applications without a hearing.
Thank you very much, Dr. Gauderman. Turning to two of our immigration attorneys, I'd like to ask Maria Baldini and Natalie Hansen how COVID-19 is impacting your work as immigration attorneys. Natalie?
Thanks, Liz. So there's been a variety of ways that our work has been impacted. First, just the logistical sort of day-to-day work has been impacted as we're all trying to work from home and limit the exposure that our clients have to contracting COVID, obviously by trying to work remotely as much as possible. With a community in which some people do have great access to computers and printers, and then others just don't, and so that makes the work just logistically very challenging right now. There's also a question of working within a court jurisdiction where the court might have jurisdiction over multiple cities and counties that are under different stay-at-home orders or have different rules. And so that's also been, challenging to work with, coordinating clients and filings and things that Maria will talk to in a bit. And then another piece that I think is important to mention is the way that COVID has really been impacting and devastating the detained population in the immigration detention centers. So on April 20th, there was a federal district court that granted a nationwide preliminary injunction that said that ICE was supposed to take into consideration vulnerable populations health-wise, their health concerns, to let them out of detention during this time because of risk of COVID. And that we just have been seeing not being applied as widely as we would have hoped. It's not incredibly surprising, but it's just been a real challenge to the asylum seekers and other people who are unfortunately detained right now. So we've been trying to do a lot of advocacy around getting people released from detention centers so that they can fight their asylum cases outside of the detention center, which is something that's always been a part of our work, but now is just feels especially important due to the real health and safety concerns of having COVID. I know here in Texas, COVID has been tested positive for in many of the detention centers and is just spreading very rampantly. So those are some of the things that that I've been experiencing as an immigration attorney, since COVID, and trying to really balance the important work that we're trying to do on behalf of the client community with also the health and safety of the community.
Thank you, Natalie. Maria, what are the biggest challenges posed by COVID-19 in your work?
Thanks, Liz. So there are three main areas that have really impacted upon attorneys beyond what Natalie's discussed. One is just the uncertainty of the court schedules. Are the hearings actually going to take place or are they not? So when COVID-19 initially came into play with the stay-at-home orders, the courts were closed, but we would often find out, for example, on a Sunday night at midnight, that the hearing the next day was not actually going to go forward. So on the one hand, we're grateful that we've got the closures so that everyone can stay safe and not become infected. On the other hand, we are still scrambling as attorneys to meet court filing deadlines. And in particular, here in Chicago, we still had to file all of our documents, our pretrial briefs, in the month of April, because the court had notified the bar that the filing deadlines remained in place, regardless of any closures or postponements of the actual hearings. So for the cities where there were prior shortages of immigration judges, and then weather-related closures over the last 6 years, and of course several different federal government shutdowns over budget issues, some people now have been waiting 5 years or longer. And the question then arises, especially for those who are applying for asylum, are they actually finally going to get their hearing and their day in court? So clients are also afraid oftentimes to give confidential information through like a Zoom call or a GoToWebinar type call. As we've all seen, the Zoom calls have been bombed, so to speak, or that there isn't always absolute confidentiality in those calls. Another issue that has impacted us greatly has been delays in mail delivery and courier delivery, especially when we are trying to file for court deadlines. I know myself, one of our packets that for a case that was supposed to go forward in May was actually lost for 7 days by the courier. In that same case, we also had filed a motion to accept a late filing by an expert witness for their extensive affidavit because that expert witness actually came down with COVID-19. In another case, the expert witness was unable to access their university office because of a mandated stay-at-home order. And in his or her office, of course, was the research needed to be able to finish the expert witness affidavit. So at least at this time, we are able to file copies of signatures on documents. However, for the clients that don't have access to a smartphone to download a DocuSign or other type of program, it creates even more obstacles for us to get signatures on affidavits or applications and be able to file those with the court. So as we are moving forward, there's also this tension. People want to be heard. They want to have their day in court. On the other hand, there's still the grave risk to everyone of the possibility of contracting COVID-19. And related to this last point is we're grateful that, of course, EOIR has allowed attorneys now to appear telephonically. And there's a June 11, 2020 memo that was issued by the EOIR executive or director that is going to allow for more issues to be decided by motion and for respondents and attorneys to appear telephonically. However, what has come out in many of the standing orders around the courts with respect to filing deadlines and other related issues is that if we appear by phone, then as attorneys, we are essentially agreeing to waive our client's right to object to any documents that are introduced during the hearing on the basis that we can't review the documents because we're not physically present in court. So this raises another issue for us on the ethical side, but at the same time, if an attorney is in one of the high-risk categories or lives with someone who is in a high-risk category, then it almost becomes this very difficult dilemma about whether to appear in court for that individual hearing or not. So those are some of the things that make it somewhat difficult for us as attorneys in trying to best represent our clients and prepare their cases timely.
Thanks so much, Maria, and thank you, Natalie. Turning now to our expert witnesses here today, I wanted to ask Dr. Gauderman and Dr. Torres how COVID-19 has impacted your work on asylum cases these last months. Dr. Gauderman?
Hey, thank you, Liz. Well, I think it's first might be useful to explain what an expert witness does, because our role is distinct from attorneys, and I think people are more familiar with what the work of attorneys. Expert witnesses provide affidavits on country conditions that are pertinent to a specific asylum claim, and we provide testimony in immigration hearings. Unlike attorneys, we are not advocates. Instead, we provide objective information and we offer professional opinions based on our research that help substantiate asylum claims and ultimately assist the judge to make an informed decision on the merits of an applicant's claim. COVID-19 court closures and the postponement of hearings have made this work more difficult. Detained hearings continue to be scheduled, but have also been postponed because of lockdowns due to the spread of COVID-19 in these detention centers. These lockdowns have made it difficult to contact applicants and to prepare them for their hearings. And for applicants who contract COVID-19, their illness is also a concern that can postpone a hearing. In one case I'm working on, the detained applicant's hearing had been already repeatedly postponed before COVID-19. And we were informed that COVID-19 was in his detention center and his detention center went on lockdown. We were unable to contact the applicant for weeks. Weeks later, we learned he had actually contracted COVID-19. He is still ill today. His hearing kept being rescheduled multiple times, but we were not notified. As an expert witness, what this meant for me is that I repeatedly had to get ready to prepare for a hearing with the attorney, and then that meeting was postponed. Now, because of the time that has elapsed between my original affidavit and when the hearing might be held, I have had to produce a supplemental affidavit. And then in addition, because of the time lapse, the attorney that was originally on this case is now leaving the law firm as of this week. And the hearing for this individual is now again been scheduled for next week. So now we're in a situation where we have a new attorney. I'll have to prepare with a new attorney. We'll have to go over the supplemental affidavit again. This attorney has filed for a continuance, but right now we don't know when that hearing is going to be held. It could be held on the date that's scheduled. Now, for non-detained individuals, these, as Maria mentioned, our filing dates have been enforced, even though these hearings have been postponed indefinitely. And again, for an expert witness, this means that we have to write new affidavits and supplement and increase our research for each case that we work on. So in one case that I worked on, and we had the hearing in January, the judge determined that he wanted to schedule a hearing in order to issue an oral decision, but that hearing was postponed because of COVID-19. And now this hearing, in order to issue the decision, has been postponed to 2022. So it's likely we will have to do more updating before that hearing is held. So these are some of the difficulties for expert witnesses that we face in having to conduct new research and to have schedules that are very fluid at this time.
Thank you, Kim. Dr. Torres, what do you see as the greatest new challenges in your work as an expert witness? What has COVID done to that work?
Well, I agree wholeheartedly with Dr. Gauderman that the scheduling is a key problem. In addition to that, it's also melding in the scheduling with a rapidly growing amount of extra work in our regular jobs as professors. And then in addition to that, when we think about how country conditions are changing, they're changing really rapidly as our own healthcare systems are strained. More so are the healthcare systems of Central American countries, for example. They are severely strained, and this poses not just strain on healthcare systems, but actually strain on political systems, as Central American countries are ill-equipped to deal with this. The level of poverty that existed there to begin with is very high, and so when we might say a basic precaution might be to wash your hands in many areas of Guatemala, for instance, that's not an easy ask where there isn't easy access to running potable water. Another problem that has arisen in addition to changing political and health conditions in the country is really the beginning of a new particular social group, which are the people who have been deported from the United States, from US detention to Guatemala, who are now facing severe stigma and persecution, I would say. Because Guatemala has signed the Safe Third Country Agreement, there have been both Guatemalans and non-Guatemalans sent to Guatemala, and there have been entire plane loads in which there's a very high percentage of people who have been sent who are COVID positive. And this has created real fears in Guatemala for contagion. In fact, there are estimates that the main vector of introducing COVID-19 to Guatemala has been deportees. And so the stigma that they face is real, and it is responding to the actual threat that they have brought to the country. And so what that means is when people are deported to Guatemala, they face even greater danger, because not only for the original reasons that made them flee, but because they are now seen as people who are hurting the country. And this has led specifically to threats to lynching, burning individual persons, and so on. There's another impact, which is the impact on gender-based violence. And this is a really complex impact in that in Guatemala, to give you an example, this is the only country that I provide country conditions advice on. In Guatemala, the collection of gender-based violence data has been constrained. Advocates for gender-based data are saying it's very hard for us to tell who is experiencing gender-based violence, but we can tell there are a large number of disappeared women. And so what has happened to those women, we do not know. And so that's a bit complex, right? Because the data for an increase in gender-based violence is not present there. While we know that it is taking place, there's some evidence of missing persons that we know that gender-based violence is taking place, but the data is not being collected. We can, though, ascertain that in all likelihood, once we are able to collect data, once we are able to ascertain what happened to the missing women, we will see that there is an increase in gender-based violence in Guatemala, as there has been in the rest of the world. The last thing I would say, it's just like in our context, courts have been suspended, and so cases for gender-based violence that would have otherwise been persecuted in Guatemala are not because of COVID. So these are multiple challenges. So challenges for the expert in terms of their own management of time, their own management of the data that they need for their expertise, but also the challenge of rapidly changing conditions that it's very hard to keep track of.
Thank you so much, Gabby. Thank you, Dr. Gauderman. Turning now to Anna Cabot, I have two questions for you about CGRS, the Center for Gender and Refugee Studies. First, could you please describe for us what CGRS does and how this is changing under COVID-19?
Sure, thanks, Liz. CGRS, or the Center for Gender and Refugee Studies, offers technical assistance to attorneys across the country who represent asylum applicants, and we are continuing to do so during the COVID-19 shutdown. While immigration courts and asylum offices have largely been closed, hearings in some circumstances for detained asylum seekers have gone forward, despite these restrictions, as you've heard my colleagues discuss. As a part of our technical assistance program, CGRS is gathering and disseminating materials to help attorneys understand and cope with COVID-related policies. CGRS has also joined the ACLU, the Texas Civil Rights Project, and Oxfam America, and filed the first legal challenge to the CDC order restricting immigration at the border as a violation of the Public Health Service Act in companion cases called JBBC v. Wolf and GYJP v. Wolf. The order authorizes the deportation of unaccompanied children without any process, even if the child is fleeing danger and seeking protection, and even if the child shows no signs of having COVID-19. Now, nothing in immigration law authorizes this order, and it violates our international legal obligations to protect people fleeing persecution and torture. These lawsuits charge the administration with falsely contending that this was authorized under public health provisions, even though these provisions have rarely been used and never have been used in this way. This case cites violations of the Torture Victims Protection and Reauthorization Act, the Administrative Procedure Act, the Immigration and Nationality Act, and the Convention Against Torture itself. CGRS also continues its representation of individuals seeking asylum, usually with gender or gang or family-based cases at the appellate level. And we recently won a victory in the First Circuit, which held that the Department of Justice cannot use the Attorney General's decision in matter of AB to deny asylum to domestic violence survivors without a full consideration of the facts and legal arguments in each case. This case is called De Peña Paniagua v. Barr.
Great. Well, can you tell us a little more about major cases CGRS continues to pursue as the pandemic and executive orders on border policy unfolds?
So we're also involved with the ACLU National Immigrant Justice Center and Human Rights First in a case called UT versus Barr. And this case challenges the Safe Third Country Agreement with Guatemala. This litigation challenges this policy because this policy bypasses protections that are built into the expedited removal process, the Safe Third Country position, and the withholding of removal statute to protect people fleeing violence or torture. We're also involved in a case called Nora versus Wolf, which challenges the expansion of the migrant protection protocols, also known as the Remain in Mexico program, the expansion of this program to the Tamaulipas region of Mexico because of the well-known and extreme harms that migrants are subject to there. The plaintiffs in this case are asylum seekers who fled violence and persecution, but instead of allowing them to pursue their case in the safety in the United States, the Trump administration forced them back across the border into Mexico to await their proceedings in Tamaulipas, where they've been subject to serious harm, including kidnapping, assault, and rape. And CGRS finally is co-counsel with the ACLU and Public Citizen in a case challenging the migrant protection protocols more generally, and is amicus on litigation challenging the transit bar, where asylum applicants who have passed through another country on the way to the US are barred from receiving asylum if they did not apply for asylum in another country.
Thank you so much, Anna. And thank you everyone for these very brief updates on your work. We could go on for much longer, I'm sure. Dr. Gauderman, before we conclude, can you tell our audience about where they can get more information about asylum and what they can do?
Yeah, thank you, Liz. I would encourage people to look at the resource guide that I prepared. It includes organizations and websites that would be helpful for people to keep informed about immigration and asylum. It's really important that everyone remain informed and to communicate that their views on asylum and immigration to their representatives. Democrats and Republican administrations have narrowed the grounds for asylum and narrowed the ability for people seeking asylum relief in our country. Make sure that your representatives know your views on asylum. Now, immediately what people could do is they could, there's a public comment period on the new regulations, the new rules that have been proposed on June 11th. The comment period runs from today, June 15th, to July 15th. And I encourage people to look at the resource guide, become familiar with the proposed changes for rules, and to submit their own public comment on this important topic.
Thank you, Dr. Gauderman. And on this resource page also, you can find links to a variety of immigration rights and services centers, and we hope that everyone will look at those, as well as this last reference to the work of our group on the Handbook for Practicing Asylum, which you can find under the Greenleaf Conference on the reference list. Thanks so much to all of you. It's wonderful to see each other remotely, and also to all of you who are watching. We hope you found the webinar interesting and useful to you, and that you'll continue to follow our Practicing Asylum handbook as we move forward with support from WISC and from the ACLS Mellon. Be safe, everyone, and take care.